Question 1. Estate planning. Trusts during an emergency response where multiple areas are impacted. An elder law attorney is advising client on the establishment of trust to protect assets while maintaining Medicaid eligibility. The client is concerned about asset transfer penalties and the ability to retain some control over their assets. Which type of trust would be the most appropriate for Medicaid planning? A. Revocable trust. B. Irrevocable Medicaid asset protection trust map. C. Special needs trust. D. Charitable remainder trust. Answer: B. Irrevocable Medicaid asset protection trust map. Explanation: Medicaid has strict income and asset eligibility requirements, and improper transfers of assets can trigger penalties due to the 5-year look-back period for Medicaid eligibility. To protect assets while qualifying for Medicaid, a Medicaid Asset Protection Trust (MAPT) is the most suitable option because it is irrevocable, meaning assets placed in the trust are no longer considered the grantor's personal property. For Medicaid eligibility purposes, the grantor can retain some control, such as selecting the trustee and directing distributions under certain conditions. The trust can protect assets from Medicaid estate recovery after the grantor's death, while the other options are incorrect. A. Revocable trust. This does not protect assets from Medicaid because the grantor retains control, making the assets countable for eligibility. C. Special needs trust. These are designed for beneficiaries with disabilities to maintain eligibility for public benefits like SSI and Medicaid, but they do not protect the grantor's assets for Medicaid purposes. D. Charitable remainder trust. This type of trust provides income to the grantor and donates remaining assets to charity, but it does not help with Medicaid eligibility. Relevant law: 42 U.S.C. SS 1396, Medicaid Trust and Transfer Rules. Question 2. Guardianship and conservatorship. In a case where multiple parties have different objectives, a 75-year-old woman with early-stage dementia is involved in a legal dispute where her children are contesting who should be her legal guardian. The court must determine guardianship while considering the woman's rights and best interests. What is the primary factor the court will consider when appointing guardian? A. The financial ability of the potential guardian. B. The expressed wishes of the individual if they had prior capacity. C. The ability of the guardian to manage the individual's estate effectively. The relationship between the proposed guardian and the ward. Answer: B. The expressed wishes of the individual if they had prior capacity. Explanation: Guardianship cases must balance protecting the individual with preserving their rights and autonomy. Courts generally give priority to an individual's expressed wishes if they were made when they were legally competent. Under the Uniform Guardianship and Protective Proceedings Act (UGPA) and most state laws, courts look for previously stated preferences, such as endurable power of attorney or advance directive. If no prior instructions exist, the court assesses the best interest of the ward considering their health, well-being, and the potential guardian's ability to fulfill responsibilities. Why the other options are incorrect. A. Financial ability of the potential guardian. Financial stability is important. Courts prioritize the guardian's ability to care for the ward rather than their wealth. C. Ability to manage the individual's estate. This is relevant for conservatorship, which deals with financial matters, but not necessarily guardianship, which concerns personal care. D. Relationship between guardian and ward. While courts prefer close family members, the best interests of the ward take precedence over family ties. Relevant law: Uniform Guardianship and Protective Proceedings Act (UGPA) SS 310 and state-specific guardianship laws. Question 3. Elder abuse and exploitation. While analyzing the root causes of sequential problems in elder care facilities, a state investigator uncovers evidence that an elderly resident's bank account has been steadily depleted through unauthorized transactions by a caregiver. The resident, suffering from mild cognitive impairment, was unaware of these transactions. Under federal and state elder law, what is the best legal course of action to address this financial exploitation? A. File a lawsuit against the caregiver for fraud and seek financial restitution. B. Contact the financial institution to reverse unauthorized transactions and close the account. C. Report the case to Adult Protective Services, APS, and law enforcement. D. Request the resident's durable power of attorney to take control of the finances. Answer: C. Report the case to Adult Protective Services, APS, and law enforcement. Explanation: Financial exploitation of elders is a growing concern and is addressed under state elder abuse laws and federal protections such as the Elder Justice Act, 42 U.S.C. SS 1397 1397 meters 5. The best response is to report the abuse to Adult Protective Services (APS) and law enforcement, as they have legal authority to investigate and intervene. Why the other options are incorrect. 8. Filing lawsuit for fraud. While civil lawsuit may recover damages, it does not immediately stop ongoing abuse or protect the victim. Criminal charges may also be warranted. B. Contacting the financial institution. While reversing unauthorized transactions can help, banks may not act without legal intervention, and this does not prevent future abuse. D. Requesting the durable power of attorney (POA). This may help manage finances, but it only works if the POA was set up before the exploitation occurred and does not address potential criminal activity. Relevant law. Elder Justice Act 42 U.S.C. SS 1397 1397 meters 5. Mandatory reporting laws in most states and Adult Protective Services (APS) guidelines. Question 4. While investigating a complicated issue between different stakeholders in an elder's estate, dispute arises regarding the validity of handwritten will created by the elder before passing. The elder's children argue that the document was written under undue influence, while longtime caregiver claims that the will is valid and properly executed under state law. The elder had declining cognitive function at the time but was not declaredly incompetent. What legal principles should govern the validity of this will, and how should the court determine whether it was executed under undue influence? A. The will is automatically invalid because it is handwritten and lacks witness signatures. B. The court must determine whether the elder had testamentary capacity and whether the caregiver had confidential relationship that led to undue influence. C. The children's claims automatically take precedence over the caregivers because family members have superior legal standing in will disputes. D. The will is presumed valid unless the caregiver can prove that the elder lacked capacity at the time of writing. Answer. B. The court must determine whether the elder had testamentary capacity and whether the caregiver had a confidential relationship that led to undue influence. Explanation. This question addresses holographic wills, testamentary capacity, and undue influence, key concepts in elder law and estate litigation. Holographic wills. Many states recognize handwritten holographic wills, even if they lack witness signatures, as long as they meet statutory requirements. However, other states require formal attestation for a will to be valid. Testamentary capacity. Courts assess whether the elder had the mental ability to understand the nature and extent of their estate, who their beneficiaries were, and the consequences of their actions when creating the will. A diagnosis of cognitive decline does not automatically mean incapacity. Undue influence. The caregiver's role is crucial in evaluating whether there was influence. Courts examine factors such as the vulnerability of the testator, the opportunity for influence, and whether the provisions of the will are unnatural or favor single individual disproportionately. If confidential relationship existed between the caregiver and the elder, there may be presumption of undue influence, shifting the burden of proof to the caregiver. Incorrect answers. A. Incorrect because holographic wills are valid in some states without witnesses. Incorrect because family members do not automatically have superior claim over non-family beneficiaries. D. Incorrect because the burden of proof typically shifts to the alleged influencer in cases of confidential relationship. Question 5. During a comprehensive review of a process that needs improvement in a nursing home's admission policies, it is discovered that new residents are required to sign an arbitration agreement waiving their right to sue in court. One resident's family challenges the agreement, arguing that their elderly relative was under duress and did not understand the legal consequences of signing. What factors will the court consider in determining the enforceability of the arbitration agreement? A. Whether the resident was presented with alternative dispute resolution methods and legal counsel before signing. B. Whether the agreement was signed voluntarily, knowingly, and without coercion or undue influence. C. Whether the nursing home had policy stating that arbitration agreements are mandatory for all residents. D. Whether the family members had reviewed and agreed to the terms on the resident's behalf. Answer. B. Whether the agreement was signed voluntarily, knowingly, and without coercion or undue influence. Explanation. This question tests knowledge of arbitration agreements in elder care contracts and contract law principles. Arbitration agreements in nursing homes. Nursing homes often require arbitration agreements, but courts scrutinize them to ensure they were entered into voluntarily, informed consent, and competency. A contract is only valid if the signer understood the terms. The court will examine whether the resident had contractual capacity, meaning they comprehended the nature of the agreement at the time of signing. Duress and undue influence. If the resident was into signing or lacked meaningful choice, the agreement may be voidable. Courts also consider whether the arbitration clause was hidden in fine print or misrepresented. Incorrect answers. A. Incorrect because legal counsel is not mandatory for signing a valid arbitration agreement. C. Incorrect because mandatory arbitration policies do not override the requirement for voluntary agreement. D. Incorrect because only the residents informed can matters unless there was legal representative with authority, e.g., power of attorney. Question 6. When implementing new protocols in a shared environment like an assisted living facility, disputes often arise over residents' rights and facility rules. Resident refuses to comply with newly enforced policy restricting visitors during flu season, arguing that it violates their right to private association. The facility justifies the rule as necessary health measure. What legal principles should be considered in resolving this dispute? A. The facility has absolute discretion in enforcing policies and residents must comply. B. The resident's right to private association is absolute and cannot be restricted by facility policies. C. The facility can impose reasonable restrictions, but they must balance public health concerns with residents' rights under state and federal laws. D. The policy is automatically void if not previously approved by all residents. Answer. C. The facility can impose reasonable restrictions, but they must balance public health concerns with residents' rights under state and federal laws. Explanation. This question explores residents' rights in assisted living and the legal limits of facility policies, resident rights and regulation. Federal laws like the Nursing Home Reform Act, NHRA, and state regulations protect residents' rights, including autonomy and association, health, safety considerations. Facilities can impose reasonable restrictions for public health and safety, but must not unduly infringe upon fundamental rights. Balancing rights and public health. Courts analyze whether restrictions are necessary, proportional, and applied fairly. Incorrect answers. A. Incorrect because facilities must comply with federal and state resident rights protections. B. Incorrect because rights are not absolute. Public health concerns justify certain limitations. D. Incorrect because facility policies do not require unanimous resident approval. Question 7. In the process of evaluating risk management strategies for a commercial property insurance policy, an insurer discovers that the policyholder made an error in the property's square footage on the application. The misrepresentation was unintentional and did not significantly impact the premium calculation. However, the insurer now wants to void the policy based on this mistake. Under standard contract law and insurance principles, what is the most appropriate legal response to this situation? A. The insurer can void the policy immediately, as any misrepresentation invalidates an insurance contract. B. The insurer must prove that the misrepresentation was intentional and materially affected the risk or premium calculation before voiding the policy. C. The policyholder is automatically liable for fraud, and the insurer can both void the policy and demand repayment of past claims. D. The insurer must continue coverage but can it the premium retroactively to reflect the correct square footage. Answer. B. The insurer must prove that the misrepresentation was intentional and materially affected the risk or premium calculation before voiding the policy. Explanation. This question tests knowledge of misrepresentation in insurance contracts and the principles of materiality. Material versus immaterial misrepresentation. Not all errors on an insurance application justify policy cancellation. A misrepresentation must be material, meaning it affects the insurer's decision to issue the policy or the premium charged. Intent and good faith. Insurance contracts operate under the doctrine of utmost good faith. Ubera fides, meaning unintentional mistakes that do not materially affect risk do not typically void policies. Legal courts require insurers to demonstrate both materiality and intent to void policy based on misrepresentation. Incorrect answers. A. Incorrect because immaterial misrepresentations do not justify policy cancellation. C. Incorrect because unintentional errors do not constitute fraud. D. Incorrect because insurers typically cannot retroactively adjust premiums unless specified in policy terms. Question 8. During an in-depth analysis of an auto insurance claim, an adjuster discovers that the insured was using their personal vehicle for business deliveries, a use not disclosed in the original policy application. The insurer denies the claim, arguing that the policyholder misrepresented the vehicle's purpose. The policyholder contends that they were unaware their business use required different coverage. How should court determine whether the insurer's justified? A. The insurer must prove that the policyholder knowingly misrepresented vehicle use and that the misrepresentation was material to the risk assessment. B. A claim should be paid in full, as the policyholder was unaware that their use of the vehicle required separate coverage. C. The insurer's denial is automatically valid because the policyholder's use of the vehicle was inconsistent with the coverage described in the policy. D. The insurer can only deny the claim. The policyholder's employment contract specifically required business use coverage. Answer A. The insurer must prove that the policyholder knowingly misrepresented vehicle use and that the misrepresentation was material to the risk assessment. Explanation. This question examines insurance contract misrepresentation, risk assessment, and claim denial criteria. Material misrepresentation. If the business use of the vehicle increased the insurer's risk, it may be material misrepresentation. Justifying claim denial. Knowledge and intent. Courts differentiate between innocent non-disclosure and intentional misrepresentation. The insurer must prove that the policyholder knowingly failed to disclose business use. Policy terms and exclusions. If business use is explicitly excluded in the policy, the claim may be denied even without intentional misrepresentation. Incorrect answers. B. Incorrect because lack of awareness does not necessarily override policy terms. C. Incorrect. Misrepresentation must be intentional and material to justify claim denial. D. Incorrect because an employment contract is unrelated to the insurance policy's terms. Question 9. A homeowner files a claim after discovering extensive water damage in their basement. The insurer denies the claim, citing an exclusion for damage caused by long-term leaks. The homeowner argues that they were unaware of the leak and that the damage was sudden. What key legal principles should be considered in determining whether the denial was justified? A. The insurer must prove that the homeowner intentionally ignored the leak before denying the claim. B. The burden of proof is on the homeowner to demonstrate that the damage was sudden and accidental rather than gradual. C. The insurer must cover the damage unless they can prove the homeowner caused the leak through negligence. D. A claim must be denied automatically as any water damage in a basement is excluded under standard policies. Answer. B. The burden of proof is on the homeowner to demonstrate that the damage was sudden and accidental rather than gradual. Explanation. This question explores policy exclusions, burden of proof in insurance claims and water damage coverage, sudden versus gradual damage. Many homeowner policies cover sudden and accidental damage but exclude gradual deterioration, e.g. slow leaks or mold. Burden of proof. The policyholder provide evidence such as contractor assessments showing that the damage was sudden. Insurer's position. The insurer does not have to prove that the homeowner ignored the issue, only that the damage falls under an excluded category. Incorrect answers. A. Incorrect because intent is not required for exclusions to apply. C. Incorrect because negligence is different from policy exclusions. D. Incorrect because exclusions vary and not all basement water damage is excluded. Question 10. In the course of conducting an audit on workers' compensation claims, an insurer finds that an employee who filed claim for back injury was actually involved in recreational sports league. The insurer suspects fraud and initiates an investigation. What legal principles govern the insurer's ability to deny the claim? A. The insurer must provide clear and convincing evidence that the injury was unrelated to work and occurred during the employee's personal activities. B. The claim must be denied immediately as participating in recreational sports voids workers' compensation benefits. C. The insurer must prove that the employee intentionally misrepresented their injury regardless of when or where it occurred. D. The claim must be paid unless the employer provides written proof that the employee was engaging in non-work activities at the time of injury. Answer. A. The insurer must provide clear and convincing evidence that the injury was unrelated to work and occurred during the employee's personal activities. Explanation. This question deals with workers' compensation fraud, burden of proof, and claim denials. Causation of injury. Workers' compensation covers injuries arising out of and in the course of employment. If evidence shows that the injury occurred outside of work, the claim can be denied. Burden of proof. The insurer must establish clear and convincing evidence, e.g. medical records, surveillance, that the injury did not result from work-related activities, misrepresentation, and fraud. If the employee intentionally misrepresented the cause of injury, criminal fraud charges may apply. Incorrect answers. B. Incorrect because recreational activities do not automatically void claims. C. Incorrect because misrepresentation alone does not determine coverage. Causation does. D. Incorrect because the insurer, not the employer, has the burden of proving the injury is non-work related. Question 11. While analyzing the root causes of sequential problems in an insurance claims process, an underwriter notices a pattern of increased delays in policy approvals. Upon investigation, it is discovered that certain high-risk applicants are being flagged for additional manual review, leading to longer processing times. What would be the most effective course of action to balance risk management and efficiency? A. Remove the manual review process for high-risk applicants to speed up approvals. B. Automate the review process using risk-scoring algorithms while maintaining manual oversight for flagged cases. C. Extend processing times for all applicants to ensure equal scrutiny. D. Approve high-risk applications immediately to reduce processing backlogs. Answer: B. Automate the review process using risk-scoring algorithms while maintaining manual oversight for flagged cases. Explanation: this question addresses risk management, automation, and process efficiency in the insurance industry, balancing risk and speed. Manual reviews slow down approvals, but removing them entirely, option A, increases underwriting risk. Automation as a solution. Implementing risk-scoring algorithms helps prioritize cases, ensuring faster approvals while maintaining risk assessment accuracy. Option B. Equal scrutiny is inefficient, extending delays for all applicants. Option C. Creates unnecessary bottlenecks. Automatic approval is risky. Immediate approval of high-risk applicants. Option D. Increases fraud potential. Question 12. In a multi-location scenario where consistency requirements must be met, an insurance company expands into new states, each with different regulatory requirements. What is the best approach to ensure compliance while maintaining operational efficiency? A. Implement a single standardized policy across all locations, regardless of regulatory differences. B. Develop region-specific compliance protocols while maintaining a centralized policy framework. C. Allow each location to operate independently and adjust policies based on local laws. D. Focus solely on meeting the minimum compliance requirements in each state. Answer: B. Develop region-specific compliance protocols while maintaining a centralized policy framework. Explanation: this question explores regulatory compliance, operational efficiency, and policy standardization. Regulatory variability. Insurance regulations differ by state, requiring tailored compliance strategies. Best practice. A centralized policy framework ensures consistency, while region-specific protocols allow compliance with local laws. Option B. One size fits all fails. A single policy. Option A. Risks non-compliance in some locations. Decentralization causes inconsistencies, allowing each location too much autonomy. Option C. Leads to operational inefficiencies. Minimum compliance is risky. Focusing only on minimum standards. Option D. Can expose the company to legal and reputational risks. Question 13. During a comprehensive review of a process that needs improvement, an insurer finds that claim processing times vary widely between adjusters, leading to customer dissatisfaction. What strategy would best address this inconsistency? A. Implement a strict time limit for all claim reviews to ensure uniformity. B. Use data-driven performance metrics to identify best practices and standardize processing methods. C. Assign all claims to a single centralized team to ensure consistency. D. Prioritize speed over accuracy to reduce delays. Answer: B. Use data-driven performance metrics to identify best practices and standardize processing methods. Explanation: this question tests process standardization and performance optimization. Data-driven standardization. Identifying and implementing best practices ensures both speed and accuracy. Option B. Time limits can hurt accuracy. Strict time limits. Option A. Can compromise quality. Centralization may reduce flexibility. Single team. Option C. May create bottlenecks. Speed alone is risky. Prioritizing speed. Option D. Increases error rates. Question 14. When implementing new protocols in a shared environment, an insurance company transitions to an AI-powered fraud detection system. Some employees resist, fearing job losses. What is the best approach to ensure a smooth transition? A. Mandate immediate compliance and eliminate manual reviews entirely. B. Offer training programs and emphasize AI role in supporting, not replacing, employees. C. Reduce the workforce to align with automation improvements. D. Allow employees to opt out of AI integration. Answer: B. Offer training programs and emphasize AI role in supporting, not replacing, employees. Explanation: this question examines change management and employee adaptation technology, Training and support reduce resistance. Educating employees on AI-assistive role helps ease concerns. Option B, mandating compliance without transition fails. Forcing immediate adoption. Option A, creates resistance. Job cuts are premature. Reducing the workforce. Option C, harms morale and may not be necessary. Opt-out creates inefficiency. Employees avoiding AI. Option D, leads to operational inconsistencies. Question 15. In an environment where different components must interact, an insurer upgrades its policy management system to integrate with external databases. Some data mismatches cause claim denials. What should be done first? A. Immediately approve or flag claims to avoid customer complaints. B. Develop data validation checks to detect incorrect mismatches before claim processing. C. Manually verify each claim before approval. D. Discontinue integration with external databases to prevent errors. Answer: B. Develop data validation checks to detect incorrect mismatches before claim processing. Explanation: this question assesses data integration and error management. Proactive validation prevents issues. Automated data validation minimizes errors and ensures accurate claims processing. Option B. Proving all claims increases fraud risk. Blanket approval. Option A invites fraudulent claims. Manual verification is inefficient. Every claim. Option C is time-consuming. Disconnecting databases is regressive. Eliminating integration. Option D reduces efficiency. Question 16. During a critical transition period where existing processes require modernization, a financial institution faces legal concerns regarding elder financial abuse. What legal framework should be prioritized to ensure compliance and protection for elderly clients? A. The Gramm-Leach-Bliley Act GLBA for financial privacy regulations. B. The Elder Justice Act IJA for addressing financial exploitation and abuse. C. The Securities Exchange Act for governing investment transactions. D. The Uniform Commercial Code UC for commercial contracts. Answer: B. The Elder Justice Act IJA for addressing financial exploitation and abuse. Explanation: elder financial abuse is a significant legal issue, especially during financial institution transitions. The Elder Justice Act IJA was established to combat elder abuse, neglect, and financial exploitation, making it the most relevant framework here. The Gramm-Leach-Bliley Act GLBA focuses on financial privacy but does not target elder abuse. The Securities Exchange Act primarily regulates securities markets, and the Uniform Commercial Code UC deals with commercial transactions rather than elder abuse protections. Compliance with IJA ensures that banks, investment firms, and financial advisors actively prevent financial exploitation of seniors. Question 17. In a high-stakes environment where multiple challenges arise simultaneously, an attorney is advising a client on structuring a Medicaid asset protection trust mapped while ensuring eligibility for long-term care benefits. What key factor must be considered to avoid penalties? A. Ensuring the trust is revocable to maintain flexibility. B. Transferring assets into the trust at least 5 years before applying for Medicaid. C. Appointing the grantor as the trustee for continued control over assets. D. Keeping all financial accounts outside of the trust to simplify tax reporting. Answer: B. Transferring assets into the trust at least 5 years before applying for Medicaid. Explanation: a Medicaid asset protection trust mapped helps protect assets from Medicaid spend-down rules, but Medicaid imposes a 5-year look-back period on asset transfers. If assets are transferred into the trust within 5 years of applying for Medicaid, the applicant may face penalties. Revocable trusts. Option A. Do not protect assets. Medicaid purposes. Appointing the grantor as trustee. Option C. Would negate the trust's effectiveness in shielding assets. Keeping assets outside the trust. Option D. Defeats its purpose. Proper legal planning ensures that assets are transferred well in advance of Medicaid applications. Question 18. While investigating a complicated issue between different family members regarding the probate of a holographic will, what primary legal requirement must be met for such a will to be valid? A. It must be signed and witnessed by at least 2 people. B. It must be entirely handwritten and signed by the testator. C. It must be notarized to be legally binding. D. It must be submitted to a court-approved estate executor before death. Answer: B. It must be entirely handwritten and signed by the testator. Explanation: a holographic will is a handwritten will signed by the testator, but it does not require witnesses. In many jurisdictions, courts validate such wills by confirming the handwriting belongs to the deceased. Traditional wills, option A, require witnesses, but holographic wills do not. Notarization, option C, is not a general requirement for holographic wills. Pre-submission of a will, option D, is not a legal requirement. Courts often scrutinize holographic wills for authenticity, so estate planning attorneys advise against them when possible. Answer A. The DNR must be signed by the patient and a healthcare provider. Explanation: a do not resuscitate DNR order must be legally documented and signed by both the patient or their legal representative and a healthcare provider. Verbal statements, option B, are not legally binding. Nursing homes cannot override a valid DNR. Option C, as doing so would violate patient rights. DRS apply in multiples. Option D, including hospitals, nursing homes, and home care, provided they meet legal requirements. Ensuring proper documentation is critical in emergency situations. Answer A. The DNR must be signed by the patient and a healthcare provider. Explanation: a do not resuscitate DNR order must be legally documented and signed by both the patient or their legal representative and a healthcare provider. Verbal statements, option B, are not legally binding. Nursing homes cannot override a valid DNR. Option C, as doing so would violate patient rights. DRS apply in multiples. Option D, including hospitals, nursing homes, and home care, provided they meet legal requirements. Ensuring proper documentation is critical in emergency situations. Question 20. When implementing backup procedures across various estate plans, an attorney advises a client to use a pour-over will. What is the primary function of this legal instrument? A. It automatically distributes all assets upon death without probate. B. It transfers remaining assets into a trust upon the testator's death. C. It allows creditors to claim assets before distribution. D. It serves as an irrevocable will that cannot be changed. Answer B. It transfers remaining assets into a trust upon the testator's death. Explanation: pour-over will ensures that any assets not already in trust are transferred into it upon death. It acts as safety net in estate planning. Probate is still required. Option A, but assets eventually move into the trust. Creditors do not receive priority. Option C, simply because of pour-over will, it remains revocable. Option D, as long as the testate live. Estate planners often pair pour-over wills with revocable living trusts to simplify asset management. Question 21. In a case where multiple parties have different objectives regarding a guardianship petition, what legal factor is most crucial in determining whether a guardian should be appointed? A. The financial assets of the proposed ward. B. The ward's mental and physical capacity to make decisions. C. The relationship between the proposed guardian and the ward. D. The number of family members opposing the guardianship. Answer B. The ward's mental and physical capacity to make decisions. Explanation: courts evaluate potential ward's capacity when deciding on guardianship. Financial assets, option A, may be relevant for conservatorship but do not determine the need for guardianship. Family disputes, option D, do not override medical and legal assessments of the ward's capacity. Guardianship decisions focus on protecting individuals who cannot be formed decisions due to age-related conditions or disabilities. Question 22. While analyzing the root causes of sequential problems in elder abuse cases, what type of abuse is most commonly reported? A. Physical abuse. B. Financial exploitation. C. Emotional abuse. D. Neglect. Answer B. Financial exploitation. Explanation: studies show that financial exploitation is the most common form of elder abuse, often perpetrated by family members or caregivers. Physical abuse, option A, is serious but less frequent. Emotional abuse, option C, is prevalent but harder to detect. Neglect, option D, is common but does not surpass financial exploitation in reported cases. Legal frameworks such as the Elder Justice Act, Adult Protective Services Act's regulations help combat this issue. Question 23. During a comprehensive review of a process that needs improvement, a law firm evaluates its power of attorney (POA) policies. Which factor is most critical when determining the validity of a durable POA? A. The principal must sign the POA while mentally competent. B. The agent must be a family member of the principal. C. The POA is automatically revoked upon the principal's death. D. The document must be renewed every 5 years to remain valid. Answer A. The principal must sign the POA while mentally competent. Explanation: the durable power of attorney POA remains effective even if the principal becomes incapacitated, but it is only valid if the principal was mentally competent at the time of signing. Family relationship, option B, is not a requirement. Any trusted individual can be named as an agent. POAs do terminate at death, option C, but this is not validity requirement. There is no 5-year renewal requirement, Option D. Durable PO remains in effect until revoked or upon death. Question 24. In a situation where formal requirements conflict with practical considerations, an executor is struggling to distribute estate assets due to ambiguous language in a will, what legal principle can help resolve this issue? A. The doctrine of cypres. B. The rule against perpetuities. C. The principle of testator's intent. D. The statute of frauds. Answer: C. The principle of testator's intent. Explanation: courts prioritize the testator's intent when interpreting unclear or ambiguous wills. Judges analyze the document's wording, surrounding circumstances, and legal presumptions. The doctrine of cypres, option A, applies mainly to charitable trusts. The rule against perpetuities, option B, governs long-term property interests, and the statute of frauds, option D, deals with enforceability. Certain contracts, ensuring well-drafted, will avoid reliance on judicial interpretation. Question 25. When developing a solution that must address opposing needs, a business owner seeks to protect assets while qualifying for Medicaid. What estate planning tool is best suited for this goal? A. Irrevocable trust. B. Revocable trust. C. Joint tenancy ownership. D. Transfer on death. Todd deed. Answer: A. Irrevocable trust. Explanation: an irrevocable trust protects assets from Medicaid eligibility calculations while preserving them for heirs. Once assets are placed in this trust, the owner loses direct control, satisfying Medicaid's rules. Revocable trusts, option B, do not shield assets from Medicaid because the grantor retains control. Joint tenancy, option C, may complicate estate planning but does not protect assets. Medicaid spend down. Todd deeds, option D, avoid probate but do not safeguard assets for Medicaid purposes. Question 26. While examining inconsistencies across various units of an elder care facility, administrators find that residents' health directives are not being followed uniformly. What is the best legal approach to ensure compliance? A. Require all residents to have court-appointed guardian. B. Implement standardized advanced directive review process. C. Mandate that all residents use the same healthcare proxy. D. Adopt one-size-fits-all policy for medical decisions. Answer: B. Implement a standardized advanced directive review process. Explanation: a standardized review process ensures that residents' healthcare directives are properly documented and honored. Court-appointed guardianships, option A, are unnecessary unless the resident is legally incapacitated. Mandating single healthcare proxy, option C, infringes on personal autonomy. One-size-fits-all policy, option D, would violate patient rights. Decisions should reflect individual preferences. Facilities must ensure legal and ethical adherence to patients' advanced directives. Question 27. During a major transformation where existing methods of estate taxation are being reevaluated, what is the most effective legal strategy to minimize federal estate tax liability? A. Keeping all assets in a revocable trust. B. Gifting assets to heirs before death. C. Relying solely on the step-up in basis rule. D. Placing all assets in joint tenancy with right of survivorship. Answer: B. Gifting assets to heirs before death. Explanation: gifting assets before death can reduce the taxable estate and take advantage of the annual gift tax exclusion, $18,000 per recipient as of 2024. Revocable trusts, option A, do not reduce estate tax liability since assets remain in the grantor's control. The step-up in basis rule, option C, benefits heirs but does not minimize estate tax. Joint tenant, option D, avoids probate but does not reduce the taxable estate. Well-planned gifting strategy is key to estate tax reduction. Question 28. In an environment where different components must interact efficiently, a hospital is revising its policies on healthcare proxies. What is the key requirement for a valid healthcare proxy document? A. It must be signed by the proxy agent. B. It must explicitly state all potential medical decisions. C. It must be signed by the principal and witnesses. D. It must be reviewed annually to remain valid. Answer: C. It must be signed by the principal and witnesses. Explanation: a healthcare proxy medical power of attorney is valid when signed by the principal and at least one witness, depending on state laws. The proxy agent, option A, does not need to sign the document listing every possible medical decision. Option B is impractical as the document allows broad authority. There is no legal requirement for annual review. Option D. Periodic updates are recommended. Healthcare facilities must ensure compliance with state laws. Question 29. When implementing new protocols in a shared environment, a legal team must ensure proper execution of a revocable living trust. What action is necessary to fully fund the trust? A. Drafting the trust document alone. B. Titling assets in the name of the trust. C. Naming the trust as a beneficiary for all accounts. D. Notifying the IRS of the trust's creation. Answer: B. Titling assets in the name of the trust. Explanation: a revocable living trust only controls assets that are properly titled in its name. Simply drafting a trust, option A, does not fund it. Naming the trust as a beneficiary, option C, is useful for life insurance or retirement accounts but does not apply to real estate or bank accounts. Notifying the IRS, option D, is not required for standard revocable trusts. Funding ensures the trust functions as intended. Question 30. While updating traditional approaches where interconnections between estate and tax laws evolve, which factor best determines whether an estate tax return Form 706 must be filed? A. Whether the estate includes real estate holdings. B. Whether the estate exceeds the federal exemption threshold. C. Whether the deceased had a valid will. D. Whether the executor wants to expedite probate. Answer: B. Whether the estate exceeds the federal exemption threshold. Explanation: the requirement to file Form 706 depends on whether an estate exceeds the federal estate tax exemption $13.61 million for 2024. Real estate holdings, option A, alone do not trigger Form 706. Having a valid will, option C, is unrelated to estate tax filing. Probate, option D, is a separate legal process from estate taxation. Executors must evaluate the total taxable estate and file Form 706 if required.